Right, this is case number 21-153-657. This is Young Numic Private Student Loan Trust versus Clarence Deal. Matters before the court set on for review on today's date. Your appearance for plaintiff.
Good morning, Your Honor. Jennifer Dillow, P69855, appearing on behalf of the plaintiff.
All right, thank you, Ms. Dillow. Good morning to you. Looking now for Mr. Clarence Deal, if you're here a second.
Good morning, Your Honor.
Good morning to you, Mr. Deal. All right, Madam Counsel, update me on what's going on here. I know I set it on for review on today's date, and I have some numbers here. But talk to me and update, please.
Yes, Your Honor. There was a judgment entered, and this court entered an installment order of $100 per month in December of 21. This court held a review hearing in May of 22 and increased the payment to $150 per month. This is the second review hearing. There's a balance outstanding of $17,656.43 as of today's date.
Defendant is up on the payment. Is that correct?
Yes, Your Honor. There was just one issue in May of 22 with the payment not being received. The defendant made some payment to cover that missed payment.
Thank you, Madam Counsel. Mr. Deal, is that a correct assessment of where things are now to the best of your knowledge, sir?
Yes, Your Honor. The payment in May had got lost in the mail, so I was in touch with the Weltman, Weinberg, and Reese to make it up, and we eventually got it figured out.
All right, very well. Thank you. So I'll go ahead and continue the partial payment order in this matter. It looks like there's been every effort to keep that going now, and so I don't know if I need to set another review date. I would hate to see you get off the plan because then that could return to some type of garnishment. But I'll go ahead and set it where you can go ahead and continue making payments, and I'll set it without a review date at this time. All right,
Great, thank you, Your Honor.
Thank you.
The court is calling case number 22-179-759. That's TJ Medical Supplies versus City of Detroit. The matter is set before the court for a pretrial date. Your appearance for TJ Medical, please. All right, do I have anyone from the City of Detroit regarding this matter at this time? All right, the court will pass on this one at this time. I'll come back to it shortly. All right, the court now calls case number 22-193-983. This is Credit Acceptance Corporation versus Jessica Mathis. The matter is I set this matter on for a scheduling conference. I received a letter that I believe is offered as an answer in this matter. That document is dated October 22nd. Your appearance for plaintiff in this matter, please.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
All right, thank you. Good morning to you, Mr. Werber. I am looking for Jessica Mathis. If you're on the Zoom, please say something at this time. Counsel, have you had any contact with Ms. Mathis?
No, I did receive the letter you referred to, but other than that, I have not had contact with her.
Thank you, Counsel. All right, and the record should reflect that the court did send out a notice that was sent out on the 5th of December. I believe we had to do an address correction. And so previously she was notified at the Chandler Park address, but in December, the court re-noticed the matter to Collingham Street, as that was the address that was used by Ms. Mathis in sending out her answer to this matter. All right, so she's had ample time to respond or to appear in court. The nature of her response to this matter is that she indicates that she believes that the vehicle that she purchased was a lemon she had some concerns in that regard. She's not here to litigate the matter on a date that is duly scheduled. Counsel, your pleasure at this time, sir.
Your Honor, at this time, I would ask for a default for her failure to appear.
All right, under these circumstances where a defendant has raised issues but has not appeared in court, the court will grant the petition for entry of default, as that was noted on the notice that failure to appear regarding this matter under item 3, failure of defendant to appear in a civil case may cause a default judgment to be entered. That notice was duly given. So I will grant your petition for entry of default. I do see in this matter, counsel, that there is an Antonio Mitchell. Apparently there was no service there. Is that?
That is correct, Your Honor.
All right, very well. So the court will enter a default as it relates to Ms. Mathis, and will enter judgment upon this proper presentment to the court. So ordered.
Great. Thank you, Your Honor.
All right, this is case number 22194228. This is Angela Hurst versus Midtown Auto. The matter is set before the court for a status scheduling conference. The court did receive an answer to the complaint that was filed in this matter. The complaint, just one moment. Alleges damages of $25,000. All right, do I have Angela Hurst on this Zoom? All right, do I have Earl Julian Simmons and Midtown Auto? All right, I'll circle back around and call that one again. We'll pass on for this time. All right, at this time, the court will call 22196550. This is Chief of Pontiac LLC versus Jamisha Echols. The matter is set before the court for a hearing. The court did receive an answer to the complaint in this matter. I believe that today is the date and time set for a status of scheduling the conference. So your appearance for Chief of Pontiac LLC. Counsel, you're on mute. If you're talking, go ahead and say something.
Sorry about that, Your Honor. My name is Mark Lightman, appearing on behalf of Chief of Pontiac LLC.
And your P number, if you will, for the record, counsel.
I'm actually not an attorney. I am in Austin, Texas, representing myself pro se.
All right. All right. Now I'm looking at the file, and I don't see an individual being sued here. So when you say you're representing yourself, what are you talking about? Tell me what you're talking about.
The suit is against Devon Smith and the young lady that is also listed on the complaint as defendant.
All right, and so what is Chief of Pontiac LLC? What type of entity is that, sir?
It is a company that owns over 40 properties in 4 states across country and manages those properties as well, and does the repairs and the management of the properties.
All right, so the entity is incorporated somewhere. Is that true?
Yes, in Texas. It's an LLC, subchapter S Corp.
Yeah. In the state of Michigan, that entity would have to be represented by an attorney. So in order to proceed with this matter, you will have to have counsel representing you in this regard.
Okay, if you would grant me a reset, I do have an attorney that I use regularly.
Okay.
I figured, I didn't realize that since this was not an eviction matter that Michigan required that as well.
Yeah, Michigan requires that if it's an incorporated entity, you would have that entity would have to be represented by counsel.
Okay.
Let Let me see who else I have on here. Devon Smith, are you present, sir?
Present.
All right, thank you, Mr. Smith. Do I have Jamisha Eccles here somewhere? All right, so has there been any discussions regarding whether or not the parties could reach any kind of agreement in this matter? I think, how much were you suing for, Mr. Litton?
I believe that's on the complaint. I believe it was somewhere in the neighborhood of between $11,000 and $14,000.
Okay, yeah, I hadn't gotten to the complaint. I was looking at some other items. All right.
Additionally, Your Honor, the suit did ask for damages to the property. And I've got written estimates from a variety of sources. And the total came to, let's see, $24,869.90.
Yeah, and you have to, you likely have to do something about your complaint if you're going from one number to that particular number. And
Yeah, Your Honor, at this time, I probably will not try to claim most of that simply because I don't believe the defendant has the ability to pay that.
all right, got it.
So
I'm gonna go ahead. I gotta set it up for the next hearing because for the reason I indicated regarding the attorney situation. Have the two of you at all talked to see if you could get this resolved, Mr. Smith? Are you interested in doing that, Mr. Littman? Are you interested in doing that, sir?
I'd be happy to do so. I believe Mr. Smith is aware of the fact that he did not pay his rent for several months. He also has a breach of contract on an air conditioner he asked me to install for $3,000. And I believe he's,
Let me stop you. Yeah, you went beyond my question.
I'm sorry, sir.
All right, not a problem. Mr. Smith, you want to talk about this? I can put the two of you, where I'm going is I can put the two of you in a breakout room to see if you can reach some agreement to try and get this resolved. If you think that'd be fruitful, Mr. Smith, are you interested?
We can, and I will ask for the court to review my answer, the stuff that I submitted also.
Yeah, I already reviewed your answer, and I know what the nature of the complaint is. I don't know that the two of you can reach an agreement, but the only way I know that that is even possible is if you talk about it. And if you talk about it, if you can find a way to reach agreement, that's good. If not, I'm gonna have to adjourn it because of the requirement that the corporate entity be represented by counsel.
Yeah. Your Honor, I'm happy to do this. Would you have an officer of the court help us mediate or moderate?
Yeah, I mean, I would be glad to do that, but the two of you have to get that kind of started. I know you're talking
Okay.
relative, the two of you are talking relatively big numbers. I think $14,000-15,000. In terms of trying to get it resolved, you want to, the parties would have to find a way to maybe come off of that number and reach a number that accommodates both sides and maybe some type of payment agreement over time that the parties could reach. But you have to talk about it. If there's no room, then you'll come back in and then I'll set a date and we'll figure out. So, Mr. Smith, there's your notification, and Mr. Littman, I'm sending it to you as well for breakout room number 1. And when you're done, just click back in and we'll finish up on whichever direction.
Thank you.
All right, this is case number 22-190-602. This is Jordan Irby versus Dennis Sulima.
Yes, sir.
Irby on the Zoom. Jordan Irby, if you dare say something at this time. All right, I'm looking now for Dennis, last name T, and you can pronounce it for me and help me out. What's your name, sir?
My name is Dennis Tulame.
All right, thank you, Mr. Tulame. Good morning to you, sir.
Good morning to you, sir.
I see that this was a subpoena that was issued for you to appear today so that Mr. Irby or Miss Irby, whoever it is, could have opportunity to inquire regarding your assets. And the reason behind that is, of course, there was a judgment entered against you back in August of 22, and that judgment is for $8,715. You understand that that's what this case is about?
Yes, sir.
Have you spoken with Irby?
Irby, yes, sir. I have just a little bit. He just was just letting me know that I had to be on this courtroom today. I was a little confused. Because I never been in trouble with the law. So when I got this paper, I really didn't know too much about it. And I was just, can I ask you a question if that's okay?
Yeah, go ahead, sir.
So this is basically about a car that we have together that we had that he sold to me, and we had an agreement about it. But I don't know if it's too late, but he broke his end of the bargain to me. So he sold me the car as is, and the car he sold it to me for $12,000. It had sounds. He gave me rims, but he ended up taking the sounds out. The sounds were $4,000, and he told me if I didn't want the sounds, I would have to pay $7,000. I gave him $3,500, and he only said that I only gave him $3,000. So I gave him the car back initially because I didn't give him his payment. I said I'm not going to pay for a car that you told me how it was going to be set up, and you took it out, and still want me to pay, the $12,000. And I gave him the car back. I didn't have the car not even 2 months. And I gave him the car back, and because I had gotten a little car accident, and he had my house, and I gave him the keys because he came with people, so I didn't want to, I was at my girlfriend's house. I didn't want no hostility, no problems. So I gave him the key, and it was at my dad's job where it got towed at. And he went up there and took the car, and he put it in his mother's backyard, and it got stolen. He put it in the street, and then it ended up getting stolen. I had clothes and shoes in there as well.
Well, I'm looking to see if this gentleman is coming in, but you probably are going to want to file a motion to try to set the judgment aside and raise those issues. Right now, what has happened is that because you did not respond to the case at the time required by law,
she gave you your number anyway. This is crazy.
The judgment was entered by default. So you could file a motion to set that default aside and ask for a hearing on it. You have to file that on the second floor of the 36th District Court. There's a way to do it online. And that's how you could revisit the issue of of what happened in this case.
Okay.
The claim against you or the judgment against you right now, as I indicated, that judgment is $8,700. And for sure, if someone took something out of the vehicle that should have been put in the vehicle that was included in the deal, then you probably would be entitled to an offset for that amount. But again, you have to go back and try to get this judgment set aside. I don't see Mr. Irby here. I'm going to wait a few moments because the nature of the hearing today is to find out what money you have, like that, so that the defendant could the plaintiff could go after and try to collect on this judgment. That's the only issue that I could address today. But the issues that you raised, if you file paperwork on the second floor, asking to set that judgment aside, then I will be under duty to take a look at that and try to figure out whether the judgment should be set aside or if you put in there some issue that should reduce the judgment. But you have to put that in writing, a proper motion. But if you file a motion, you have to put in there why you didn't answer on time. That's called, you got to show good cause, why you didn't answer.
Okay.
Put a good reason in there why you didn't answer on time. And then you have to show that you have a defense to the claim. And that's what you've been talking about today. You said that you said that number one, the price that he's charging you should be $4,000 less because something was missing on the vehicle. So,
Right.
in addition to that, you're saying that you returned the vehicle to him.
Yes, sir.
That you should offset because the vehicle was returned. But you got to raise all of that. You got to put it in a written document to try and get that and file it before the court. File a motion to set aside the default judgment.
Okay.
All right. Just sit tight. I'm gonna see if the other side comes in. If not, then I'll likely dismiss the subpoena and then you go forward accordingly. But I got to wait a few more minutes. All right.
Okay.
All right. Thank you, sir. All right, this is case number 22-193-341. This is Latanya Gully versus Clement Wright. The matter is before the court, set on for, I think that I set this for a review date, a pretrial conference. All right, very well. Do we have Latanya Gully on the Zoom? If you're on the Zoom, say something. If you're on mute, just hit star.
Yes, I'm present.
All right, good morning to you, Ms. Gully. All right, I'm looking now for Clement Wright. Mr. Wright, Clement Wright. Or any attorney representing Mr. Wright. Just one moment. Brian.
It's supposed to be a Clement Wright and an Ellen Wright.
All right, just one moment.
Can you hear me? I'm in Zoom court right now. I told the person gave you my number that. Please not disturb me again. Thank you.
And who are you, ma'am, that just came in? What's your name?
Jessica Mathis.
All right, Ms. Mathis, yeah, I called your case earlier and you were not here. Where were you? What happened? Did you get tied up somewhere else?
They had me in another courtroom. They had this number as 360-53400.
Right. And that should have directed you, that number should have directed you here, but that's where you were. That's where you were.
Yeah, I just received your 336 from the courtroom that I was at before.
Okay. All right. Yeah, because when you weren't here, I entered a default against you because the other side was here. I'm going to go ahead and set that aside now, and I'm going to set a new court date because there is a bit of a mix-up that's going on with the courtrooms. So what I'm gonna do is I'm gonna give you a new court date. I'm gonna notify the other side as well. I did receive your answer regarding this matter. And as I said, the attorney on the other side was here. So I'm gonna set that default aside that I entered against you, and then I'm just gonna give you a new court date. To come
Okay.
back. I'll notify the other side to come back as well. So I'm resetting this matter for looking at a date now. Just one moment. I'll do this on the 30th. That should be enough, right? Okay. Yeah, so January 30th, ma'am, I'm going to have you to return, and I'm going to go ahead and set that for 9:30 a.m.
Okay. Will it be virtual also?
Say that again. You broke up a little bit. What did you ask me, ma'am?
I said, will it be a virtual hearing also?
Yes, that will be a virtual hearing as well. We got a mix up with the numbers 534 and 336. My courtroom is 534, but they've got me using Zoom 336. So
Okay.
you get a notice in the mail, and the notice might have 534 on it, but you should know that when you come in, go ahead and put in 336, because like I said, there's a bit of a mix up. Come back to where you came today.
Okay.
This is the right courtroom that you should be in. And where if you end up somewhere that you shouldn't be, tell them that you need to be in Judge Donald Coleman's court. There's a female is Judge Coleman Jones, but I'm the only male. Coleman.
I believe that's where I was at the first time.
So if you want to be with Judge Coleman, the guy, man, okay. And so tell them that's where you're supposed to be, and somebody will direct you to make sure you get in to see me.
Thank you. I appreciate it.
All right. I wish you well. Good day.
Thank you.
Matter report for the record, that was the suffix 3983 credit acceptance versus Jessica Mathis.
Right, I got it, Judge. I got it.
All right, and Miss Gully, I'm coming back to you in just a moment, ma'am. Just sit tight.
Okay.
Yeah, I see. I think I see the attorney on the other side now. That's the Gully versus Wright matter. Also, a second defendant in that matter appears to be Alan Wright, Clement Wright, and Alan Wright. Your appearance, counsel, for defendants in this matter. I see the attorney there.
He's on mute.
Attorney Bryant, if you're there, please unmute yourself. Good morning, your appearance.
Good morning. Can you hear me?
I can hear you now.
Oreen Bryant, attorney for Mr. Wright, P47247.
Thank you, Madam Counsel. I see your answer regarding this matter. There's also a Ellen Wright regarding this matter. You're not representing Ms. Ellen Wright, is that correct?
Yes, I am.
Okay.
I'm sorry, I forgot to include her. And the reason I forgot to include her, Your Honor, is that she's wrongfully added. So that will be a motion to dismiss her. But I also have some other motion requests.
All right. All right. All right. So, and let's go ahead and get right to it then. I know Ms. Gully is on this Zoom, and I know, Ms. Gully, that you're suing in this matter, and you indicated for $25,000. And this has something to do with claims regarding a flood at a living unit, and also some claim of some threats at that location. That's the nature of the complaint. And then I noticed, of course, with the following of the answer, that there are various defenses that have been raised in this regard. All right, Madam Counsel, what do you wish to raise at this time, please?
Well, I like Mrs. Gully also had a motion to amend to add me as a party, and that was in the small claims case. However, both of those cases has been joined with your case. The small claims case indicated $6,500. Your case has no greater than, but both of them are now your cases. So what I was looking at the pleadings, Mrs. Gully has pleadings that are not in compliance with the court rule. So I thought the only way that I could determine what the real legal issues might be is to ask for discovery. Now, the Michigan court rules says that there's no discovery in district court cases unless the judge provided an order of such. So I'm asking for that order, unless you want me to do a motion to ask for that.
The court would typically grant opportunities for discovery where discovery could be relevant and helpful to the adjudication of the matter. And this does seem to be one of those cases where discovery would be instrumental in narrowing what the issues might be.
Lawyer and client
Granted,
sexual relationship.
the other issue going to be
Lawyer and client sexual relationship during the case.
According to American Bar Association,
A lawyer should not have conversations with client and to
It's just some background noise. Sorry to interrupt. That's coming from Ms. Gully, I believe. Some background.
All right, Ms. Bryan, anything else you wanted to raise by way of motions you indicated?
And a third matter is that when Mrs. Gully asked that I be added to the case, I've never received the whatever that was that I be added. So I have not responded. I have asked the court to send me a copy of whatever that was. And of course, because she said she doesn't have a copy. And I've asked the court to send me a copy, and then I would pay for the charge. However, I haven't received it. Now, I don't know, and I guess I didn't check whether or not the courts are open, and then I could come down and get a copy.
All right. So the only file I have in front of me is the 3341. I know that there was a motion to consolidate. Do you have the other file number, Madam Counsel?
The one that was in the small claims?
Well,
Yeah, the motion to consolidate is in the case 22243175 GC.
Give me that one. Sorry.
Okay. 22243175 GC.
Okay, my clerk is pulling some information on that.
David Robinson on his case.
off the record on this. What are you seeing regarding Ms. Brown's case? Is that my case or not? You're checking on.
Ms. Brown, she needs to be in Judge Coleman courtroom, and I keep sending her a text, and she's telling me that I'm wrong. And I looked in the system. She needs to be with Judge Jones Coleman. I sent her the phone number.
All right. So Ms. Brown, I want you to know that you need to go to the courtroom. I heard that case, but that case was assigned to Lydia Nance Adams. She retired, and the judge that took over her docket, is Judge Jones Coleman. So while I handled it in the interim, it belongs to Judge Jones Coleman. So you need to go to 534-360-534-0000. I did hear it before, but I was hearing it temporarily because it belonged to a previous judge. A new judge has taken over that judge's docket. So that's why you need to be at 534. All right. So we're back on the record regarding the Gully versus Wright matter. I remember this case now where there was a previous case that was in front of, or a subsequent case that was filed in front of Judge Robinson. And so that case is being consolidated with the case that I have today. So that I will grant the motion for consolidation because that case was filed after this case. So mine appears to be the one that's first in time. All right.
Excuse me, Your Honor. Excuse me. This is Latanya Gully.
Go ahead,
This is Latanya Gully. May I speak? My case was filed the same day. I don't know what's going on.
Okay.
It's supposed to went to Judge Judy Court, and they sent it to your court.
Yeah, got it. So
I'm suing Ellen Wright and Clement Wright and this lawyer and her law firm.
All right, ma'am.
I sent you an email.
What I have is, I do have the two lawsuits that have been filed. In both of those lawsuits, the defendants are Clement Wright and Ellen Wright. If you wish to sue someone else, you'd have to file something in addition to what I have now, because both of these cases are against the respective defendants that I mentioned, as Clement Wright and Ellen Wright. So if you're going to sue somebody else, there's something else that you have to do because the attorney is not included in either one of these. That may be your desire.
I already did that, sir. I had to amend it. I paid to have amended. Judge Robinson is aware of it. He told her that he approved the amendment. In other words, it's to proceed. She's aware of that. She claims she didn't get nothing in mail. I did. Judge Robinson have his with the copies I sent out. This case has been going on since August of 2022. She don't want Ellen Wright to be involved because she thinks she's Ellen Wright. She's having sex with Clement Wright. She questioned me about my sex life with Clement Wright. So she is a conflict of interest. And it says a lawyer cannot have a sexual relationship with a client nor during a case. So I'm trying to figure out what's going on. I put several complaints in against this attorney.
Well, Your Honor,
I have a voice recording of her asking me about when the last time we fucked or had sex.
Oh, Your Honor, all of that is incorrect. I don't know.
No, I have your recording, your voice, you on the phone, you.
No, you would not have had that. You have something with me on the phone because, Your Honor, I can't hear you. Okay.
I need to stop. Ms. Gully, I listened to you until you stopped talking, and then Ms. Bryan started talking. You start talking again. You can't do that.
Okay.
So you can't do
I
that.
never stopped talking. She interrupted me, sir.
No, as I said, you interrupted her. Now, if you want to, if you don't want to follow my direction, then that's going to cause another problem. You interrupted her. If you want an opportunity to talk, then I'm gonna let you talk, and nobody can interrupt you. And then when Ms. Bryan is talking, you can't interrupt her. Ms. Bryan, you had something you wanted to say, ma'am. Go ahead.
What I had indicated to you earlier, Your Honor, I don't know what her motion to amend says, because when Judge Robinson asked her to send me a copy, she said she didn't have one. he had indicated that he would send it then, but I never received it. And then I've asked the court to send me a copy because I didn't know exactly whether the court was open. I don't mind coming down to the court to find out whatever that is. And I don't know what she is exactly talking about today or even before, because I have had a conversation with her over the phone where I told her that there was an attorney listed on the case. I can't remember his name. And it was Mr. Attorney Gregory. He was listed on the case, but it turns out he didn't file a proper pleading to be entered. And I think you indicated that. But she was babbling on about something related to me. And I said, I don't know what you're talking about. And I told her that I would not be able to talk with her because there's an attorney listed on the case. So all this other things that she's bringing up, I'm not aware of any of those. And of course, whatever she just last said about me and Mr. Clemens, I don't know Mr. Clemens. So I don't know what she's talking about, but I'd be glad to respond in a proper pleading.
Let me ask you this, Ms. Have you received a summons and complaint suing you?
No, Your Honor. I haven't received anything trying to sue me. And then she just said today, my law firm. On the register of actions in the other case, it does mention something related to amendment.
Right. You know it do.
And Judge,
I don't think that I've given Ms. Gully the opportunity, the right to speak just yet. But if you speak up again, ma'am, then I'm going to completely cut you off where you won't be able to say anything. So I think that it makes sense that when one person is talking, that until that person is completed, and until I come back to you and give you an opportunity to talk, that you have to shut up. That's what you have to do. And if you don't do that, then you're not going to get a chance to talk. I think that's pretty simple.
Can you repeat that? Can you repeat that for the record?
Ms. Scully consistently interrupts the court. And so what I'm going to do is I'm going to go ahead and set out a schedule of discovery. I don't see anything in the file that shows that a summons was issued that allows for any other party to be added to this case. If Ms. Scully wants to sue anybody else, she has the right in law to do whatever she wants to do. Neither one of these files show that there is a summons or a complaint issued against any other party. The attorney herein, law firm, or anything along those lines. Both of these cases are cases that are directed to Clement Wright and Alan Wright. Now, the court was doing its search because I don't have the, I only have the register of action regarding the other case, but I do have the complete file on the suffix 3341. That's the case that was set up and called in front of me today. And in that case, there is no summons issue that would allow there to be a process brought against any other party. The only summons in that case is a summons that relates to Clement Wright and Alan Wright. In the subsequent case, as I've reviewed the register of action, I do not see the issuance of another summons that allows for there to be an action brought against other parties. If the defendant wishes, strike that if the plaintiff wishes to do that, there is a way at law to proceed in that regard. But procedurally, there is not another party that is a part of this at this time. The court has adopted the motion to consolidate these matters. They are consolidated in front of me. I will grant a period of discovery to allow the parties to exchange information between each other over a 60-day period of time. I will set the new date for hearing in this matter on March 13, 2022. During the next 60 days, the parties will have opportunity to exchange information if they choose to do so. And the parties must respond to such information pursuant to the court rules in such cases. I will be issuing a scheduling order. That order will be sent in the mail today, and the parties should receive it before the week is out. And that will be the schedule for this case. Again, the due date is March the 13th, and that's going to be at 9:30 a.m. March 13, 9:30 a.m. The parties may also, there's a court scheduling order. The parties may file motions and present any motion request in front of the court and set it for hearing on the 13th of March. That's going to be a pretrial date, but if you have a motion you wish to bring, a petition you wish to file, you can file it and have it heard on that date. Here is the requirement. The requirement is that you file it soon enough that the other party has at least 10 days to respond to the motion. You file a motion, it can be dispositive, or it can be a motion that allows, that is requesting something that is not dispositive. And I will hear it on the 13th, as long as you file it early enough that the other party has at least 10 days to respond to the motion. That is that will be the order that will be issued. You'll receive a scheduling order, and it will have the next court date in it. And under paragraph number 6, it will have the information I've communicated regarding the filing of motions. So you'll receive that in the next couple of days. I do wish you well. The case number for both matters will be on the scheduling order, and I'll conduct the pretrial hearing at the next action date, March 13 at 9:30 a.m. Good day.
Okay, thank you. Thank you, Your Honor.
Can you please excuse yourself off my case? I'm gonna call the Judicial Team Commission to do so.
Hey, Your Honor.
Let's see. Ms. Bryan, you're all set. You'll be receiving an order from me in the next couple of days.
Okay, thank you.
Mr. Callahan?
Yes, Judge. I believe I saw opposing counsel on the Zoom a little bit earlier, but I don't see him now on TJ Medical Supply, case number 22.
Yeah, I called that earlier. No one responded. So let me get back to it. 221797959, TJ Medical Supplies LLC versus City of Detroit. Your appearance, counsel.
Yes, good morning, Judge. John Cahalan, P 77404 on behalf of defendant City of Detroit.
Thank you, Mr. Cahalan. Did you get mixed up between these courtroom numbers or something?
Yes, yes, Judge. My apologies. And then when I logged on, I saw opposing counsel, at least their name and the case number they were on was here. I don't know if I've tried calling over to the main line of the office at the law firm there and haven't been able to get through to the handling attorney. So I don't know if they've what their status is at this time. So.
All right. So yeah, I know there's a little bit of a mix-up going on there. So I see that there is an answer, and it looks like I set up a schedule regarding this file previously. And so
Yes, Judge.
Trial date set on this back. What's the status of things? Do you have any information that can update me in that regard?
I've attempted a few times to reach out to opposing counsel to see if we can work this out. I don't think it's a large amount in dispute, and haven't been able to get any contact back. So I can continue to try and do so. The judge if this court wants to set some continuing dates, obviously I'll leave it up to this court on how they want to do.
All right. Yeah. Now, I think what I'll do, counsel, is set it over for review in 30 days. I know that Mr. Vazzi's office or defendant's office is frequently involved in these kind of matters, and they're typically present in the hearing. So I'm going to go ahead and adjourn it and set it over for to the 9th of February, 2/9/23. And I'll set that up for 9:30. I'm going to get this notice out in the mail for February the 9th, 2023, 9:30 a.m. And I'll review things at that time. Hopefully the parties can make some progress towards finding out what the bottom line may be in terms of trying to resolve it. If not, we'll visit this issue and drill down on the 9th.
Okay.
All right,
Thank you, Judge. I appreciate it. Happy New Year. Good to see you.
Good to you, sir. So I'm back to Mr. Coleman, and I'm trying to pronounce it correctly. I've been waiting for the other side to come in because I know that this is there was some confusion between courtrooms. And I know that Mr. Coleman indicated to me that Mr. Irby spoke with him about being in court today. So I don't know where Mr. Irby is. So at this point, it is now approximately 10:25. This was set on for hearing at 9:30 a.m.
Yes, sir.
Plaintiff has not appeared. So the subpoena in this matter is going to be dismissed. I'll dismiss the subpoena. If you want to deal with that judgment, you got to find a way to file a motion to have that reconsidered, sir. You understand, Mr. Coleman?
Yes, sir.
All right. All right. I wish you well today, sir. Good day to you.
You too.
All right, we're back on the record regarding the subject 6550. That's Chief of Police LLC versus Jamisha Echols and Devon Smith. All right, welcome back, Mr. Lippman, and welcome back, Mr. Smith. I know you took a bit of time in there. Did you make some progress? Need engagement from the court? Talk to
Yes, sir. We almost completed. We're leaving Miss Tanisha off of the judgment because she was no longer in residence when these debts were incurred. The suit was filed based on the original lease from several years ago, and the occupancy changed. A new lease was issued, but the property management company folded up their tent and skated out in the middle of the night with my money, my keys, and my leases. So I filed based upon what I had was the most current information. We also found out, I'm sorry.
Go ahead, I'm listening to you, sir.
We also found out Mr. Smith shared with me that he believes and has confirmation from Wayne Metro, from a gentleman named Brandon Jacob, that Wayne Metro did a Recert 2 Sarah payment of approximately $5,300, which was improperly sent to the prior management company several months after I fired them. And he was able to get a copy of the check from Wayne Metro showing it was deposited at Comerica Bank. I have not seen that. However, it's of course not really fair for me to ask Mr. Smith, the defendant, to be responsible for money that somebody else absconded with that was rightfully his, and I may have to eat that. We did discuss, however, a payment amount of $200 a month on, I guess it would either be what, an agreed order or conditional dismissal, but we hadn't determined the amount total in damages. And I have not yet had a chance to email Mr. Smith a copy of the $25,000 itemization of the damage to the house or the approximately 50 pictures I took substantiating each of the charges.
All right, so I guess the only issue that was here in front of this court, unless there's something different filed, was the amount that you brought forth from the claim.
Your Honor, I do believe I did request damages to the home to be provided down the road because we didn't have the damages at that point yet. I think that should be at the bottom of my request, plus legal fees, plus post-judgment interest at 6%.
Requested those things, but that does not put the defendant on notice as to what those things are. And so there are legal procedures that would have to come into play in order for those items to be included. Of course, if you guys dismiss the case and decide that you want to hammer it out, then that would be nothing that the court's hands would be involved in. But as you have this before the court, basically when you say that there are other charges that may be there, when those charges are of any substantial nature, you would need to do something along the lines of amending the complaint to conform with that information that you discovered. I guess where the two of you are now is coming up with some bottom line number. And it seems like you got the cart in front of the horse. You got a monthly payment amount, but you don't know what the gross amount is in terms of agreement. Mr. Smith, did you have some number in mind that you felt would resolve the case from your perspective?
Can you repeat what you just said?
Yes, sir. I wanted to know whether or not you had a number in mind that you felt would be an appropriate number to resolve this case at, an amount that you could agree upon. Did you have an amount in mind?
I asked for 150, but we agreed on 200.
No, he's talking about a total dollar amount for past due rent and or the central AC and or the repairs to the damage to the house. I mean, theoretically, we have almost $40,000 that I could amend the suit and ask for if I wanted to include an itemized the damages and the evidence. Obviously, I'm not going to be asking for 40,000, and you're not going to be agreeing to that. So he is asking us if we've got 11,800 in rent and 3,000 for the breach of contract on the AC, plus an undetermined amount for the repairs and damage to the house. He is trying to ask you if you have a number that you feel comfortable with as far as the total damages to dismiss one or possibly two cases, because the damage to the house could be filed as a separate cause of action.
And remember that apparently you guys have discussed that a certain CR payment would be an offset to this amount.
Yes. And Your Honor, if we do come to an agreement here at this point, no one joined us in the breakout room. Would we have anyone that would assist us with that, or will it be my responsibility to get paperwork drafted up and forward it to the defendant?
Well, depending on what you guys agree to, the court could issue an order based upon your communication, your agreement that you reached. And of course, it could also go by way of the two of you working on paperwork to get into the court. But if you've got some number that you come to an agreement on, then obviously you put that on the record. And if that is on the record, it's agreed to by the parties, then that the court will accept that agreement and will issue an order based upon that agreement. That order could be an order dismissing the case on the condition of certain payments over a set period of time, or it could be an agreement for a judgment to begin. That there are a number of ways of doing the final part. All right, so here is what's hanging in the balance to me.
Is the balance?
Yeah, what's hanging in is theoretically this case could be somewhere else, because anytime there's a claim that's beyond $25,000, that's no longer jurisdictional to this court. The second thing is that the entity, the court could not allow this case to go forward without there being an attorney involved, unless there is an agreement that the parties reach in regard to this matter. So the case kind of hangs in the balance. I sent the two of you to have a gentleman's discussion to try and figure out whether you can find a way forward. It seems to me that you've had something of a meeting of the minds on there being some obligation that stands out there, and that there was some money paid, that there may be a third party involved in this that was cleaning whoever pockets they could. They didn't care whether it was the plaintiff's pockets or the defendant's pockets. They were collecting money, and that happens with the CR money. Mr. Smith would be entitled to a credit in that regard. And if you came to court, I think the claim that was brought here, I think you told me it was 15,000 or what did you filed suit?
I have it at 14,800 at this moment, not including any of the actual out-of-pocket expenses incurred by the sudden move out. So I've got 1,200.
Here's what I'm looking at. I got it now. I'm looking at $12,877.13. That was the amount sued for here. That's what's before the court. And obviously there was some indication that the plaintiff may wish to amend to include some other amounts that they believe they might be entitled to. In this case now, there's discovery of the $5,300 that was paid by CR. If I'm going by the complaint that was issued here, and I take into consideration an offset by the $5,300 CR payment, then that brings this case down to a $7,500 case. And then the parties could talk about what their agreement could be or not be in regard to those kind of numbers, because that's what's in front of them. If there's going to be anything else in terms of numbers, then the other stuff would be stuff that would have to be filed by way of an amendment, maybe moving outside of the jurisdiction of this court, so on and so forth. But right now, with the CR money, this is a $7,500 case, and that's really where the parties. That's where you have to start your bargain at. Now I don't know. I don't know if you guys want to bargain at that level, and if you don't, then I can stop right now and just adjourn this for council, I mean, I should say for Mr. Lippman to bring in a lawyer and then go forward.
Yeah, Mr. Smith would have to miss work, and obviously I'm incurring additional time and expense. Devon, do you have a number in mind is what the judge basically wants to know?
Yep.
Can we start it off at the 7,500, what he said, and
Well, what I would like to,
then I send you all the stuff over from the Sarah, from Brandon
Yeah.
and all that.
okay, with all due respect to both of you, what I would like to do is request that it be the amount that was filed in the suit, because that does not include the $1,250 and change I've already spent, or the other roughly $24,000 of damages to the house. And then what we will do is simply provide for an offset should I end up getting the money from Sarah. And that will settle any rent issue. If there's anything else, we'll worry about that separately at another time.
Look, if you gotta resolve, here's the rub here is that you gotta seemingly a big balloon floating that the parties don't really feel. The way that you resolve this case, and now I'll drill in on it. I don't think that you were able to resolve it. But this is the way you resolve this case. If there's an acknowledgement that $5,300 was paid by Sarah, that brings down the number to $7,500 in this case. There is a dispute. There is some dispute there in that regard. It sounds like to me that what this case settles for, with the numbers that are in front of me, this case settles somewhere between $5,000 and $7,000.
Oh, Your Honor, it was also NAD 75 also that was
No,
sent to Detroit.
Yeah, that's not, Devon, that's already been taken off of your balance. And Your Honor, I'm.
Hold on a second.
Yes, sir.
Mr. Smith, something about 975. Were you talking about 975 or 9,000?
$975. It was two checks.
All right, so I knew there was other disputes. Here's my point. My point, what I'm saying to you guys, if you can agree on resolving this case today based upon what was filed before this court and based upon the new information that's coming before this court, the way that this type of case settles, it settles between $5,000 and $7,000. Your dispute is over that. Is somewhere in that range of $5,000 to $7,000 for purposes of settling this case. And if that's not the pace that you're on, then you're never going to be able to settle it, because you're still going to talk about stuff that's not included right now. If you talk about stuff that's not included, you'll never be able to settle this case.
No, sir. No, that would be a separate matter. My only concern is Sarah typically notifies me whenever a case is approved. And when I looked into this matter in June and October, they told me that the case was not able to be found. So I'm not really sure exactly what that means. So that was the reason, sir, why I was asking if we could do the approximately 12 with the condition that if I end up, getting the 5,300 or the proof of that, then that would be credited toward the balance.
Well, the problem, I guess, with that is that you already have evidence that they paid that money.
No, I have no evidence at all, and I've not received any emails. The only thing I've received, and I actually talked to Marshall Brooks, who's was the head of Sarah in East Lansing, and they weren't able to pull up any record under the Sarah Research 2 number that I provided them. So at this point, I'm just taking it on good faith that Mr. Smith, the defendant, has information, but I have absolutely nothing. And in actuality, my research on 2 different dates in June and October show that there's no record of that case in the Mishta computer. So that's why I'm asking it be included. And if it is proven.
Again, I think I think the case is stuck more than I thought it was, because it seems to me that what you were telling me, Mr. Lippman, is that Mr. Smith had shown you something regarding that $5,300 payment.
No, he just told me about it today in the breakout room. It's the first I've heard of it.
All right, very well, got it. All right, so let me let me go ahead and set the case over, because of the need for council to be involved in this. Maybe the two of you can find a way to.
Right there, one file, that's it.
Are we, Your Honor, are we able to go to a breakout room with an officer of the court and just take a few minutes to see if we can get this resolved?
Yeah, and, Mr. Smith, you want to go back to breakout room and talk about it some more?
Okay, we can.
Do you have someone that can join us to make a record of what we discuss and agree upon?
No, I can't do it that way. Once you, if you discuss something and you agree upon it, then you come back in the courtroom and then we make a record of what the agreement is. If you
Okay.
reach an agreement.
Before you send us out, can I just ask Mr. Smith, is he agreeable to the 12,000? And then if that payment, we've got proof of that payment coming through, then that immediately is removed from the judgment amount?
You guys go and talk about that, because that's a big one. And if you can reach an agreement, I mean, if you can't reach an agreement, then you simply can't. I told you what I think this case resolves at. And that's based upon it's based upon 100 years of experience, give or take 50 years. But try it. If you can't get there, we'll figure out a way. We'll figure out a way to go forward. I think you should be able to get to where this case needs to be. Obviously, if someone has defrauded regarding a certain sum of money, then you may be.
Hello, Judge. I can't hear what he's saying.
We're not talking to you, ma'am.
Can't hear me, Ms. Hurst, because I'm not talking to you. I'm talking to other people right now. I'll come to you shortly. All right. Then there's a way to assert fraud claim to bring those kind of things back in, etc. All right. So let me send you to try and talk about, maybe it makes sense to you to do something different than what makes sense to the court. And if that's the case, then that's where autonomy comes in. If not, I think the perhaps the wisdom over time in terms of what I think should resolve this matter, close the book on this, is probably the way that you need to approach it. But again, there are your notifications to breakout room number 2, and I'll be here. I'll be here when you return. I know you're trying to get there.
Okay, so if we basically agree on amount, then we'll come back to the room and the court will help us with drafting the document.
We'll figure out the process from there.
Okay, thank you, sir.
Now, that agreement has to be, the court always has to be able to weigh in and say that the agreement is. That's why you have me weighing in on this side.
Okay, I'll go to the breakout room. Thank you.
For me to approve the settlement. All right. Ms. Hurst, can you hear me now? Ms. Hurst, can you hear me now? So let me.
Yep, right between those 2 ropes right there.
All right, Jordan there, last name Jordan, say something to me.
Yes, my name's Jordan Erb.
All right, thank you, Mr. Irby. I called this case earlier a couple of times, up until about 10:30, and you were not here. I suspect that you got tied up in another courtroom. Is that what happened?
Yes, they have the wrong court number on my paper. They have,
It's not really the wrong number, but there should have been a direction to send you here. You didn't get that direction earlier?
no, sir.
All right, so what happened is I waited an hour because I knew that there was that there could have been some technical problems. And after that hour, when you didn't make it here, I dismissed the subpoena. But what I'll do now that you are here is I will reinstate the subpoena. The other side, Mr. Tolomi, was here. And so I kept him here until I think it was 10:30 before releasing him, and I dismissed the subpoena. So I'm going to reinstate your subpoena, and I will give both sides a new date to come back. I recently got transferred to this particular courtroom, which is 534. Typically, the Zoom number follows with the courtroom, but they've kept my Zoom number somehow at 336. That was my previous courtroom. That's where the mix-up was. There was supposed to be a tag that would tell you when you came into that 534 to back out and come to 336. So it's not your fault. That's some technical problem that we're having here that threw you off. But I wasn't sure because within an hour you should have been able to figure that out, but they didn't help you. So I'm going to reinstate the subpoena. You'll still have an opportunity to raise whatever subpoena issues you wanted to raise. And I'm going to send a notice to yourself and Mr. Dolomite to come back to court. So let me set this up for, let's set it up for the 30th of January, 1/30/23. And that's going to be at 9:30 a.m. Now you'll probably get a notice. You'll probably get a notice from me saying, come to 534. But if for some reason you run into this problem, just come into 336 where you are today.
Okay.
That's a problem that we're trying to get worked out here. And so if you don't see me at 534, because the problem is now that the other judge is a Judge Coleman too. It's Coleman Jones, but that's a female. So you come into Judge Coleman, the male, the guy.
Okay.
So if you click in next time at 534 and you see that it says Jones Coleman or whatever, then just come to where you came to today, 336. Okay.
Okay.
I shouldn't have to tell you all that, but if it get mixed up, that's what you want to do. All right.
Okay. Thank you.
I'll see you on the 30th. You will get something in the mail in this regard, and Mr. Tolomai will be notified of the date as well.
Okay. Thank you.
I think we're gonna have to do 6. So I'm gonna start sending it out in 3 6.
Hello, Judge. This is Angela Hurst. Did you call me yet? My appointment was at 9:30, but I left my phone at home. I have to go back and get it.
That just messes everything up. Did you get the text that I sent you? Did the chat that I sent you? Ms. Hurst, did you get the chat that I sent you? Ms. Hurst, are you able to hear me?
You ain't got to go.
Ms. Hurst, are you able to hear me?
I can't hear you.
I'm just speaking. Calling.
Mr. Hurst? All right, Mr. Smith and Mr. Lippman, I see that you're back.
Yes, we have an agreement.
All right. So what is your agreement?
Our agreement was for $12,000, $200 a month, payment due February 15th or starting February 15th. And he asked for a 5-day grace period. And that once I have received confirmation that a check was issued for approximately $5,300, I agree to give him credit toward that amount toward the balance.
Are you Mr. Smith? I know you've gone back and forth on this issue today. Are you agreeable to the terms that have been set forth on the record by Mr. Lippman regarding trying to resolve this matter?
We can see, but he just disappeared again.
All right, so let me stand down until he comes back in and go from there. All right. But he's not.
By the way, Your Honor, I've been before several judges in the 36th, and I have to appreciate your patience and your courtesy. It's not always demonstrated by your peers.
Yeah, 30 years helps with that. Well, actually, you know, I find that sometimes if we give people a little bit of time to kind of think about stuff, they tend to find a way forward. And, so
But you're
thank you, sir. I appreciate it. Mr. Smith, I see that you're back, sir. You heard the term set forth on the record by Mr. Lippman.
I lost connection. I had to log back on.
Oh, not a problem. Did you hear the terms that were set on the record by Mr.?
I didn't hear anything.
Okay, all right. So he says that the two of you. He says that the two of you have come to an agreement regarding an amount of $12,000 to resolve the claims between the parties. That the agreement is that a payment of $200 would be made per month commencing on the 15th of February with a 5-day grace period. Said amount to be paid until the judgment is paid in full. There's a further agreement that upon presentment of proof that $5,300 was paid by CR regarding this particular piece of property, that the judgment amount agreed upon will be reduced by the amount of the CR check, and the payments would continue for the balance. Is that the agreement? Is that agreement acceptable to you, sir?
Yes, that's the consent judgment.
Yes, that would be a consent judgment. And you know that entry into a judgment means that there is a record generated regarding a judgment being against you. And that, you know, that could impact things that you do by way of credit, et cetera, because there's a money judgment against you. Understand that?
Yes, sir.
And you're yet prepared to go forward with this agreement, is that correct?
We're going for it.
All right. All right. Well, it seems like the parties have reached an agreement, and you do have some information that you'll be able to confirm this $5,300. Is that correct, sir?
Can you repeat your question?
You do have some process by which you can confirm that the agreement that you straight at, whereby you can confirm the $5,300. Is that correct?
Yeah, $200.
I didn't hear you there. What did you say?
You said, am I agreeing to $200?
No.
Yeah. No, I was asking you about the $5,300. You're confident that you have some proof and information.
Yes.
Establish that, correct?
Yes.
All right. All right. Very well. All right. Well, it does sound like the parties have reached an agreement, and the terms of which seem to be reasonable, and the parties seem to enter into this agreement without constraint or without being compelled to under unusual or illegal process. So I will sign off on the agreement. I will issue an order from the court that will be in the nature of a consent agreement reached by the parties under the terms that have been set forth on the record, and you will receive a copy of that order from me. That order will also dismiss the defendant Janisha Eccles from the matter.
And lastly, Your Honor, just to be clear, because Mr. Smith hopefully doesn't spend too much time in court, if he misses that 5-day grace period, my understanding is that allows the entire balance to be accelerated and due at that time. Is that correct?
That's it. Well, that's the nature of the judgment. If you don't make the payment, then the council can move forward to collect the judgment in any way that that they find that they desire to do so, garnishing bank accounts, all kinds of stuff like that.
Okay.
There is some ability for the parties to communicate. So if there is a problem, obviously, Mr. Smith, the first thing to do is reach out to Mr. Lippman and see if you guys can pull that
Well,
together.
can we also, Your Honor, put in an order, you know, if it's 3 consecutive missed payments, then somebody can move forward?
It's just one, basically.
The question was, can we put that in the question is, can you put that in the agreement?
That's what I was asking.
So, you know, you'd have to go back and talk about that. I don't know that parties have typically agreed to allow there to be 3 missed payments before they can take further action. Here's what I think may allow this to go forward, and you guys may be able to work this out. A 30-day grace period. And again, what you want to do is, if you're having a problem, you want to communicate. You got a 30-day grace period. That means that there's something that happened and that you need to make contact and say, look, it's gonna be late this month, and it's because of this, so on and so forth. And then you get that worked out. What you don't want is you don't want an artificial payment date. So if you say the date is the 15th of the month, and then every month you pay the 30th of the month, then you don't really have an agreement. So you could put in there a 30-day grace period, but that 30-day grace period does not allow for a person to be late 30 days every month. It just says that if you're having a problem, that you have 30 days to get it corrected, and if there's a deeper problem, then you want to contact the other side and say, this is what's going on, I need to do this, and maybe we can get something worked out.
Yeah, can we stick with the 5-day grace and just add 1 30-day extension will be allowed with proper notice?
You see, that's what you guys are supposed to work out in that.
Okay, well, he just brought this up when we got out of the breakout.
I know, I'm messing with the two of you when I say that. Here's what I'm getting at. I think that your communication between each other, quite frankly, I'm impressed. Usually, when it's this much involved and as much stuff has been going on with COVID and so on and so forth, and CR and what have you, usually this gets to be more of a hornet's nest. I thought I was right. So you guys are really, honestly, you impressed me with being able to kind of get some of this.
Well, thanks. I don't want to inflict my pain on either of you. Yes, it has been a hornet's nest for the last 2 years, and I haven't slept well for 2 years.
Yeah. And so what I think here with the two of you is that you're probably able to talk about it if something comes up and work at getting it resolved.
Just leave it with the 5-day grace, and I'll just have a gentleman's agreement that if he does have an issue and calls and notifies me, I'll give him a 30-day extension should he need it. Are you okay with that, Devon?
So you said if I had called with an issue, then
if you have a case where you can't make a payment within the 5 days of due, you call and let me know, and I will, as a gentleman, give you 1 opportunity to be 30 days late.
Or otherwise, and let me just throw this in since I'm weighing in with you guys a little bit. Or otherwise, I think the ideal here, Mr. Smith, is that you guys have a way to go forward with this. You know, Mr. Lippman wants to get paid the money that's due under the judgment. If you run into a problem, then he can accelerate it and go forward with this. But if you communicate that there's a problem, you're like, I'm behind on this, but you know, if you give me till the next month, I'll have both payments for this month and that month. You may be able to work that out.
Absolutely.
You know, that's how you manage stuff like this. And I don't think that there is really an agreement that can supersede being able to manage stuff. You know, and if you got somebody that you can communicate, you probably can manage it through communication. And then the last thing that I'll put out is that if you have a particular unusual hardship and you're not able to work it out, then you file a motion with the court asking for relief from the terms of the payment. That'd be something extraordinary. You lost your job. Then the court could look at the matter and say, well, I'll reduce the payment to $100 a month until he, for the next 6 months because he lost his job. But that's extraordinary. Even with the agreement, you could always petition the court for something that is different from the agreement, but it has to be extraordinary circumstances. That's only on the payment, not changing the amount of the judgment. But on the payment part of the agreement, you could file something with the court expressing extraordinary circumstances. But the first thing that you do is you talk to Mr. Lippman. You say, this is what's going on. This is how I'm going to resolve it. And then you guys try to work that out. That makes sense to you, Mr. Smith?
Mm-hmm.
That's the first time I heard,
Yes, yep.
All right. So I'm going to go ahead and make sure I get the agreement out to you with the 5-day grace period. There is a clear understanding here that there's talking about you run into a problem. And that also you could file a petition for the court to take a look at it if you run into extraordinary circumstances. Okay. And I'll get that order out to you in the next day or so.
Okay. Thank you, Your Honor. And thank you, Mr. Smith. Have a pleasant day.
Good day. Bye-bye.
Hello, hello.
Mr. Smith? All right.
Mm-hmm.
All right, you're all set, sir. I'll get that order out to you, sir.
Oh, can I give you my new updated address?
Yeah, go ahead, sir. If you want to put it, do you know how to chat it? You got to put it in the chat?
I don't know how to, let me see. Tell me if you, okay, let me see. Let me see.
Shoot.
Tell me, 25605.
You would chat it to me, Judge Cole, or to Judge Donald Coleman.
Okay. I put it in the chat. Did you see
Yeah,
it?
I got it there in Roseville on Mackinac, correct?
Mm-hmm.
All right, I got you. I'll make sure it gets sent to that address, sir.
Okay, thank you.
All right, thank you. Good day to you.
Oh, so Your Honor, you said so I got a 5-day grace period or a 30-day? Like if
You have the 5-day grace period. The gentleman agreed that he will extend 30 days to you, but he agreed to that one time. So the main thing that you have to do is if you run into a problem, contact him, talk about it. If you have an extraordinary problem, then file something with the court asking for relief from the payments, okay?
Okay.
All right.
Thank you. Bye-bye.
Bye-bye. Ms. Hurst, ma'am, are you able to hear me? I'm trying to talk to you, but, okay, unmute your device. Ms. Hurst, unmute your device so you can talk to me.
Okay, it's unmuted.
Okay, can you hear me okay?
Pretty much.
Okay, good enough. All right. So your case, I called your case earlier and nobody answered in your case. I know that you were in another courtroom, is that correct?
Yes, sir. I left my phone at home. I had to go back home and get it.
Okay, got it. All right, so, just 1 second. I did receive, a response from Earl Julian. In that response, they said that this was a false claim. They don't understand it. And they said that you continue to make false claims. But Mr. Julian has not appeared here today. Do I have a Mr. Julian on this Zoom? Well, man, what are you got down here that you're suing for $25,000? What are you talking about? That's a lot of money. What are you suing for?
Well, he stole all my stimulus checks. Then he did a medical fraud at Henry Ford Hospital and racked up over $4,000. And then CMS called me and sent me a letter for breach of contract. And then he went to my insurance again, tried to get my old insurance cards and open up a new insurance case.
So now, what proof do you have that anybody took anything from you?
Say it again.
What proof do you have that that anybody stole anything from you?
Oh, I have it right here next to me. And also, he went down there to AT&T, used his badge with his girlfriend, Kelly Wilder, and my ID, and purchased a phone.
Did you file any of this? Did you file a police report, man?
Yes, I did. I filed a police report and an identity theft report.
All right, and has anybody, have they arrested this individual? Have any action been taken in that regard?
They went to him, and she was arrested 3 times for the same thing over and over and over again. Kelly Wilder, his girlfriend. And he kept gaslighting me. I didn't know myself was there, taking my paperwork out my house and then bringing it back 3 or 4 weeks later. Then I got a PPO against him, so he wouldn't come and see me no more. And then he came over and see me anyway. And then I got assaulted by him. He punched me in my eye.
Is this somebody that you used to date?
Yes. Very abusive.
And what is Midtown Auto, ma'am?
That's where he work at. That's where his mail go. Cause he can't get a house or nothing because his credit's too bad. So he lives in hotels. And she had 3 sisters that worked in each department, like DHS, Social Security, and at the bank. They was hitting me every which way.
So ma'am, what money has been taken from you? What money did this gentleman take from you?
The 3 checks that came the year before last, and then last year when I filed taxes, my tax money, and put it on this property for property taxes. And I filed against Liberty Taxes for wrongful doing on my taxes.
So you
and with the state.
So you gave him money to pay his taxes. What happened?
No, I didn't give the money to anybody. Liberty Taxes took the taxes. Friend, pretending it was not me.
I don't know what your claim is here, man. You said, okay, let's start with this.
My claim is he stole my money, my tax money. and he did Medicaid fraud. Did Medicaid fraud.
Okay, let's start with your tax. How do you steal your tax money? How did that happen?
I went in and filed the Liberty taxes. You had to file a special form that your taxes was already taken, and I had went to the fair at AT&T. I mean on DET Fair State Fairgrounds, and she claimed me as one of her dependents. That's how she did it. She claimed me as one of her dependents. Took the taxes. She had $219 home equity credit, and took that, but she be paid it back. She be back. Then she did it again the year before last. She did it again last year. This time they applied it to their home property taxes. It was $1,800.
All right, ma'am, I don't see where you have, anything that you can show proof that anybody has taken anything. So what I'm gonna do, ma'am, I want you to. All that.
Say it again, please.
Yeah, you got a lot of noise in your background. Here's what I want to do, ma'am. I'm gonna set a date for you to come down to the court building. And I want you to bring with you any proof that you have regarding anything that may have been taken from you by Mr. Simmons. So I'm gonna set a date for you to come down and see me. That's going to be next Thursday, ma'am. 3/19.
Next Thursday.
At 1/19/23 at 10:00 a.m. You're gonna come to 36 and courtroom 534.
Okay, say it again.
January 19. That's on Thursday, not this Thursday, but next Thursday. January 19, 2023, on Thursday at 10:00 a.m. Courtroom 5.
Okay. 534.
Yeah, 534, courtroom 534. You're coming to see Judge Donald Coleman.
5. Did you say courtroom 534?
That's correct. Courtroom 534, you're coming to see Judge Donald Coleman. 10 yeah.
Donald Coleman. Come and see you personally?
Yeah, you come into my courtroom. Bring with you any proof that you have that anything was taken from you. Bring it to me so I can see it.
Okay.
Okay. All right, so I'll see you at that time.
Okay. All right, so court is over.
What is all?
All right, thank you, sir.
Two more files. I need to break that.
What's the 23 for?
I don't know, man. What did you say?
It's 23 for?
I don't know, ma'am.
January 19 at 10 o'clock, 23. That's the we get in with Zoom.
No, January 19, 2023. That's the year, ma'am.
Oh, I'm sorry. Okay. And be in your courtroom 534. Donald Coleman. Okay. Thank you very much.
Good day to you.
Good day to you also.
All right, I see a Ron on here. Why are you here?
I'm not quite sure. I was just wondering, I was trying to find my son, actually. He was being seen and I wasn't getting any answers. So I was just I was looking at his paperwork as to what judges were seeing him, and I was hoping he was going to be in your courtroom, and I wasn't quite sure how to do this virtually. I've never done it before, how to sit in on it. So I wasn't quite sure where he was at.
Got it. What type of case does he have?
It would be a weapons case.
Yeah, that would be in one of the criminal courtrooms. This is a civil courtroom. Madam Court Reporter, you have any idea where he might check to see where his son might be?
Mechanical's not any longer doing them. I'm not quite sure.
I thought I was in maybe even in the wrong building. It might be at a Frank Murphy Hall. If I was to give his name, would you be able to tell me?
Yeah,
I don't know. What did you
You
say,
mean
Madam Reporter?
You mean the judge's name?
Yes, what judge he would be seeing today.
You have the judge's name?
No, I don't. I
Oh.
thought when I read his paperwork, it was either Ramsey or I saw Mr. Giles.
Judge Giles.
So let's see if we can get Judge Giles.
His Zoom number
Yeah, his Zoom number.
or courtroom number, because he
would have to be in person there, right?
I believe so. But maybe he can call
Well,
us.
he's being held right now, so he was brought over to the courtroom, or whichever one he was at, either the Frank Murphy or there at the 36th.
Got it. All right, yeah. So he's probably likely in front of Judge Giles. We're gonna give you the courtroom phone number so you can check on that, okay?
Okay, thank you. I appreciate it.
That's 965-2564.
Thank you very much.
Okay, you're welcome.
All the best to you, sir.
Thank you.
I hope that's. He can hang up. You can,
Yeah, I know.
I'm still on YouTube.